in this position. I started in this position in December of 2021. So I've been in it for a little over a year. And I'm thrilled today to talk to you about what information privacy is, ways that we can protect privacy in our work environments, and also how we go about looking at how we might classify data, right? So since we're getting so much data, paralegals are always exposed to so much data. I think it can be overwhelming sometimes to think about how we need to protect it and how we identify what level of protection we should be putting on it. And so I'm going to start off providing you with a little bit of background about what what information privacy is, and then we'll go from there. And I really appreciate the help with the slides. For some reason, my notes were appearing in the slides. I am not super proficient with Zoom. We use Teams, and so I do appreciate the help. I'll leave time at the end for questions, but if you have pressing questions during the presentation, please do stop me. I'm happy to stop and talk about it then. Okay, thank you. So next slide, please. Okay, so what is information privacy? I feel like there's a lot of things that are talked about, and when we talk about privacy, we might be thinking about it in different aspects. So for the purposes of this discussion, we're talking about just about information privacy. So not about privacy of your person, but about the actual information. So information privacy is the right that the person has to control the collection and sharing of their personal information without consent. And when we think about this, if we think about even like 10 to 20 years ago, right, before there was a time when our data was worth so much, that this wasn't really as much of a concern, and we didn't think as much about it. We didn't think about when we gave information on websites or to apps and we gave our permissions, what might happen to that information, how we might have people who would capture our data and then sell it. As it's become a bigger and bigger thing and they've been able to monetize our data, this has become an issue. And the issue of information privacy has right alongside of it come to rise in importance at both the state and the federal level. So at the state level, so we have federal, state, and international laws that address privacy. And in the United States, we have a patchwork of privacy provisions that are done by sectors, right? So we have privacy for children, right? This is COPPA, the Children's Online Privacy Protection Act. Then many of you are probably familiar with the privacy laws that we have for finance, that cover finances, that cover medical and financial and health records, government. So we have the Privacy Act of 1974, things of that nature. So what makes us different than other countries is that if we look at the European Union, we have the General Data Protection Regulation is giving a much more comprehensive coverage. Ours is more patchwork, and then we add to that the different states that have privacy laws, so California, Virginia, and the like. And even though a lot of their laws are similar, they're not the same. So then it becomes an issue of how do you apply a framework that will cover all of this and make sure you're in compliance. So that's a bit too in-depth for this discussion. But what I want to do is lay the groundwork for this and to give us an understanding of what are all these competing things that we're looking at and that we need to be mindful of as we look at data and we look at how we want to protect data. So understanding information privacy requires, I think the main thing that I see is that it requires an awareness of the risks that are involved when you're dealing with personally identifiable information. A lot of people are still not as familiar as they should be with the sort of protections that we need to be applying to PII, and they are not really thinking about it in their day-to-day life. So as you're using, if you're looking at different case files and you're doing different things, sometimes you don't think about the importance of it and about the importance of things like getting things off of the fax machine, if people are still even using fax machines right away, right? About making sure that we've encrypted our emails if we're going to be sending any kind of PII, about any kind of intake forms that we may have that people put their PII on. So for instance, at the state, we have a DIT privacy email box where people can write in and ask questions, but it's mainly for the state. And this morning I received something that had people's PII contained in it. So now there's a duty on me to protect that information, right? It was information that came in that I wasn't expecting to come in. So part of privacy awareness is remembering the rules that should be being applied, that we should apply the fair information practice principles, and we'll talk about those later in this presentation, but about also recognizing when an issue appears that maybe we hadn't thought of or hadn't planned for. So a good way that we can start out and set the baseline for practicing information privacy is to make sure everyone in all of our companies are aware of it and are mindful of it and incorporating it into everyday life. So next slide, please. Okay, so privacy has a basis in human rights law, and in 1948, the Universal Declaration of Human Rights was adopted, and the United States signed on to that in 1992 with the International Covenant on Civil and Political Rights, and it's a legally binding international human rights agreement. So sometimes you'll find people talking about, well, is the word privacy in our Constitution, right? Or is it in the Bill of Rights, or is it in the Bill of Rights by reference? And there are some discussions that it is. And we have, like Brandeis's treatise on this. But even if we were to set all of that aside, the fact that we've signed this and we've signed on to this means that we should be being mindful of it in our everyday work environments, and we should be treating it as the right that it is. So when we think about it and we think about how we apply it, I think that we have to look at it. If we were looking at it at the larger global picture, we can see that some countries are applying their rights more vigorously, and the U.S. is in a position now where we're essentially playing catch up, right? So some states like California have adopted a more GDPR style of privacy. In other states like Virginia are adopting what we might say is maybe a little bit more business friendly and less focused on the consumer, but is still a privacy law. And then, as I'm sure everyone here probably knows, North Carolina had put forward a privacy bill, and we're hopeful that we will see that again. So I think that when we look at it in the United States, we have to look at it like at a state by state level, but then also look at the overarching federal laws that we have that are covering privacy and privacy specific to the sector in which you're working. So all of that makes for a complicated set of requirements that we're trying to figure out how are we going to be responsive to this, and how are we going to demonstrate that we're taking reasonable measures in our work environments. And so next slide. So I think that we want to start by looking at what are we talking about when we talk about PII. So PII, or personally identifiable information, I always say this comes by many names because PII is what is used in the federal realm, right? And at the state level, we have personal information. So in North Carolina, we say it's personal information. That's a person's first name and first initial and their last name in combination with identifying information. So that whole package would then be PII. So personal information doesn't include things that are publicly available in directories. So this would be things like if you voluntarily consented to have your name and phone number put into a directory, well, then that wouldn't be covered. But sometimes I think that people don't think about that and just read it like really quickly and assume that it means that, oh, your name and your phone number would by default be public. So that's not true. And that's not true when we think about our cell phone numbers, right? Very few of us have publicly available cell phone numbers. Those are usually by default private, and for good reason, especially when you're paying for people, if people call and leave you messages. So I think that those are things to think about, and to always look carefully at what a law is telling us when we look at it, and then think about if we were applying it. And I always like to think about it like 2 or 3 steps out. So what happens if I do this in this instance, then what are the ripple effects of that? And I find that privacy awareness helps us with making those right decisions. So the other thing that is not considered personally identifiable information is information that is made lawfully available to the general public from federal, state, and local governments. The one caveat I would say to this is that the state is in the process of refining the things that we do put out. And so it's possible that you could be looking at something that if you looked at it and thought that maybe it shouldn't have been public, then I would at least consider that whether or not that might have been released at an earlier point in time that's not reflective of what we currently do. So if you collect it, protect it. This is what they always say. This is what they say at the federal level. And I think that it's a great thing. Like if you see something, say something at the airport, if you collect it, protect it, right? So we want to safeguard all the PII that we have. And one of the ways that we do this is that we don't provide PII to anybody who doesn't have an official need to know. So if we were thinking about it in like law firms, we wouldn't allow access to any cases that contain PII, right, which is essentially like every case, to anybody who wasn't actively working that case. So like many years ago, when I was a lawyer in Louisiana, we used to have just rooms that were full of file cabinets, right? And any of the lawyers could walk in, open up all the file cabinets, go through and look at anything. It wasn't, it's not that we weren't following the law, it's just that the law hadn't caught up to it. So when we look at privacy and we look at the things that have been public and we look at how we have handled the protection of privacy, it's evolved. And it's evolved a lot over the last 10 to 20 years. So that's why I was talking about what we may have made available in the past. Maybe we won't be making available now. This is the reason for that. So in the past, we would have these big file cabinet rooms where you could just go in and look at anything. And you might even, like as a young lawyer, I had gone in to look at other cases to see how people had done things before me when I was new and trying to sort of get my feet. Now we would be looking at it through the lens of, is there an official need to know? So we wouldn't want to have places where people could access PII that they didn't need, no matter what their rank was within a firm or an institution. So the way that we manage, the way that we work to keep privacy and then to keep our data protected is to have the fewest eyes and hands on it, right? The more hands, the more eyes, the more likely you are to have a breach. And it's not necessarily a breach that is that happens because we don't care or whatever. It's just that the more access, the more likely that becomes. So that's how that came to be, that official need to know, is that we're trying to decrease the number of people who have access to data in order to keep it safe. So wherever possible, we do that. And then the other thing is and many of you may already know this, that there has been a federal move to decrease our reliance on Social Security numbers. This has been adopted by the state as well. One of the reasons for this is that identity theft has just been proliferating, right? And in the last 5 years alone, it keeps like doubling and doubling and doubling. And so one of the easiest ways that they can use to get information about us is through access to our Social Security number. For those of us like me who are part of the OPM breach, that is already out there, but for many, and that we want to keep their Social Security numbers either completely secret or hashed, right? It may be that if you needed somebody's Social Security number to verify something, you might be able to do that with just the last 4 digits rather than the whole SSN. And so that's something to keep in mind is, do we really need this, or can we have do we have maybe a unique identifier that we could put on this particular document to be able to then link it to that person without having that information be readily available. So wherever we can replace an SSN with a unique identifier, or even a hashed or a partial SSN, that's always a good thing to keep in mind and to think about doing. And another thing that we can think about doing is to practice the Fair Information Practice Principles. And those I will be talking about and showing you in just a few minutes. But I'd like to take this moment now to tell you, in case anybody hasn't heard the Fair Information Practice Principles, and I tend to think that they are known more by privacy folks than just everybody else. But the Fair Information Practice Principles underpin federal privacy law, and you'll see them as the foundation for the different states that have privacy laws. Those underpin those laws. The state privacy bill that we attempted to get passed here, that was part of that bill. that underpins the GDPR. It underpins big economic, like the OECD. They have adopted the fair information practice principles. And what these principles are basic ways that we should handle information fairly. And then that helps to decrease the chances of identity theft. It respects people's privacy, and it stemmed from our use at the federal level in the 1970s, our use of big computers accessing people's data, that it turned out that the way that it was being handled was determined to be not in the best way. And so these principles were put into place to help everyone to handle and safeguard data better. So I always like them as the default, because no matter what regime you're under and what you're trying to achieve, you know that at the base of almost all of them is going to be these FIPS. And if we're practicing them, then we're, at least 2/3 of the way there. So I like it for that reason. Okay, so next slide, please. So I think most of you have probably seen this, but if you haven't, this is a great presentation of what personally identifiable information means in our state. So the identifying information is listed right here on this slide. And two things I'd like to call to your attention, which is number 10, that says any other numbers or information that can be used to access a person's financial resources. So I think sometimes we look at this and we think, oh, that's not, maybe that doesn't cover it or whatever. But I think that if we looked at what could be, what could fit under 10, it's a lot more things now than when the law was written, because so many different numbers are used in that way that we need to be thinking about that. And then also number 8, which is electronic identification numbers. So electronic identification numbers could be linking to all kinds of different accounts. And if those accounts can then be accessed to get information that could then lead to financial loss. So you're thinking again, that 2 to 3 steps out, right? Not what does the face of this look like, but where does this take me? So an example of this is if we had access to someone's health portal, right? We might inadvertently get access to somebody's health portal. Well, that health portal may not have a number right then that has that information, but we could get information through the portal that could then lead to financial loss. So I think it's about looking at it logically about where does this information lead us, and what does the term identifying information really mean? And I think we also need to be thinking about it in terms of context. So when we think about what information would be sensitive or what would be personally identifiable information, we have to look at it in context. So if my name and just my work number is available, well, even though that's technically PII, my work number or my work address is general business information. So that's not a big deal if that was to get out. It's not surprising that people would need to find me in like that. But if it's my home number or if it's my cell phone number, then that's something different. And if it is my personal email versus my work email, again, something different. So it's looking at it in context, and it's looking at it in terms of the impact that it will have on the individual if that information gets into the wrong hands or is, inadvertently published. So I know that's a lot of stuff to look at, and we also have it on our website. So next slide, please. So in order to help both our state agencies and the general public, we have created this website, which provides a lot of information. This is the Office of Privacy and Data Protection's official website for the state. And what we have in there are links to privacy laws, policies, guidance. We even have some links to training. I think it's a helpful site. People tell me that it's helpful. I think one of the things to understand about it is that it's always a work in progress. I'm not originally from North Carolina, so I have I've put in my background is in from federal privacy. I was in federal privacy for many years, and I am an attorney. But so I put in all the stuff that I could think of. I've also reached out to our lawyers and the state government for their guidance on what other information I should put in here. But I'm always trying to update it to add more information that would be relevant. So if when you're looking through it, you see some stuff that you think we ought to add, please do shoot me an email. I would love to add that. I think that privacy is everyone's responsibility and it's a team effort. And so I'm always open to getting any kind of additional information that I can have that can make it better for everybody overall. But let's get into what we have here. So next slide. Okay, so what I've done is I've gone ahead and put in some of the main provisions that maybe people who are sort of new to the idea of information privacy and you're wondering where to look and to try to get sort of the foundation of what's going on. These are some good, this is a good place to look. So this first statute is that gives authority to the Department of Information Technology to be over privacy for the state. So that's why that's there. But other laws that I think that would be important for this group in particular would be things like the identity theft and identifying information law, our public records law, employee personnel records. Then there's student online privacy. I've essentially gone through most of the ones that we've seen or have seen that could be of importance. There's also links in our site to the AG's office who can provide more information from a consumer standpoint. And then we can see down here our list of ones that apply to employee personnel records. So I think all of that is a good place rather than just looking it up generally. This is a good place to get sort of an overview of some of the main privacy laws we have. We also have articles about why privacy matters, tips. The section on privacy complaints will give you information that you can get that's provided by the FTC, that's provided by the AG, and I think the FCC as well. Next slide, please. Pardon me. So then I think that it's helpful for people to know some of the major federal privacy laws that we should all be thinking about and that you may not come in contact with all the time, but when you do, could be important to know about. So for us at the state level, the Privacy Act of 1974 is a big one that applies to information held in federal systems, but it also applies to Social Security numbers, right? Because our Social Security numbers originate from a federal entity, and so they are covered by that. So that requires us at the state level to be providing notice about whether or not you have to give us your Social Security number and what authority we are basing that on to ask you for it. But HIPAA basics, I think these are super helpful for anyone. And we have on this site like a primer that comes from CMS, the federal health group, to the Federal Health Agency, to give you an understanding of what HIPAA is about and how to comply with the HIPAA privacy and security rules. Then we have our state policies. So I'm going to talk about in just a few slides about the fair information practice principles. We've adopted those. We have a media protection policy, which I'm going to talk about as well. I think this will be helpful to you in your daily lives, because what the media protection policy does and what the FIPS do is give us guidance on how to handle data and how to protect it in ways that will help us to be compliant, so that we know that we're handling it to what would be a reasonable standard. Then we also have information that's maybe more aligned to our agencies, but so we have the state has adopted the NIST risk management framework. That management framework can be applied to private entities. So you could apply that to a law firm if you were looking to do that. And you can also use information gathered that's provided in these different documents to help you with setting a base level for how to protect private information in your environment. Then at the bottom here is our NIST standard. So this is the National Institute of Standards and Technology. If anybody is not familiar with them, I love them, love them. The reason that I love them so much is that this is a national agent, a federal agency that is full of super smart people who write all kinds of guidance for us to help us with how to protect data and how to classify data and how to do all kinds of things like set up our risk management framework, how to protect data and systems, all of that. And what makes them, I think, unique and so wonderful is not just that so many people follow them and that the federal government follows them and the state government follows them. It's that unlike some other big entities like this information is free. So if you're working at a small firm or or if you're on your own and you don't have a lot of money to devote to buying, frameworks and to looking at how to apply them, this gives you all of that. And when you look into each one of these NIST guidance documents, it will have links or information about where to go for more information about a particular topic. So I really like that, in that if you're just getting started, you can read one document and then it'll lead you to the next document, then the next document, then the next document. And then before you know it, you have like this big framework of understanding of how to protect things, about how to classify things, and about why they're done in that manner. So I think for all of those reasons, it's an amazing, amazing organization. And I am thrilled that we follow them. And that so many people are dedicated to doing the best job that we can for protecting data and to providing that information for free to the rest of us. So now on to the Fair Information Practice Principles. Next slide, please. So these are those principles that I was mentioning that so many people have, so many states and the federal government and other governments around the world have adopted. These are the 8 guiding principles, and they are transparency, that an organization should be transparent and provide notice to the individual about what you're, why you're collecting it, how you're going to use it, and how you're going to maintain it. So that's essentially, that's how we would want it for ourselves, right? So whenever we're like downloading an app or something like this, we want to know, what are you going to do with my data? Why are you collecting it? Why would you need access to my camera or to recordings or anything like that if it doesn't make sense? So it's about being transparent. It's about asking, it's about explaining what you need the information for so that the person is fully aware and can make an informed decision. Then individual participation. So you should always be looking to get people's consent for the information. I feel like in the legal realm, this is a completely understood thing, not as much in other areas. So it's important to always say this, but we need to have a mechanism for people to be able to consent to giving us the information. And we also want it for documentation purposes so that we can show that we did have that. Then purpose specification. So you should tell the person specifically what it is you're collecting the information for, and then only use it for that. I don't usually see that being an issue, or at least it wasn't when I was working in a law firm, but I think it's an important thing to think about, and particularly in these times now, where there's so much more emphasis on how to monetize data, that we make sure that if we tell people what we're going to use their information for, and then that we only then use the information for that purpose. Also, data minimization. So an organization should only collect the PII that's directly relevant and necessary. So one of the ways that this sometimes comes up and that people have concerns about is that people think, oh, well, you're trying to tell me that I can't collect for the things that I may need to collect for. When I think about data minimization, what I find at the state level and what I find at law firms is that what the second part of that statement is the most important, is that we only retain it for as long as we need to fulfill the purposes. So I know many of us can think back to the big Target breach, right, years ago. One of the reasons that people were so upset with Target is that so many of us didn't even know that Target had our information, right? We hadn't shopped there in years, and then all of a sudden there's a breach, and you get notification that, your name, your social security number, all this information was taken from Target about you. And the question is like, if I haven't shopped there in years, why do you have my information anyway? So one of the biggest problems is that the more data that we're holding, the less control we have over it, right? unless we have a giant data inventory and the ability to inventory it, and we're keeping up to date on it, most of us probably have it just in different files, like on our computers, right? And different types of data will need different levels of protection on it. But the biggest problem is if we don't even know what all we have, then we don't necessarily know when it's been stolen or accessed, and when it shouldn't have been. And that even if we did know that something had been accessed, we might not know what it was or who to tell afterwards. So it's just in general a good idea that whatever the period of time is that we have to hold records for, after that period of time, that we get rid of them. And I would also recommend, having a process where you document what you have done. But that will really help the most. So in my mind, the issue isn't so much that people are over collecting, particularly in a legal environment. It's that we tend to hang on to stuff much longer than we need. And I think everybody's guilty of that. And, for the law firms that have been around for ages, many of us, could still even have a bunch of paper documents that we don't know about, right? Or don't know where it is, or we may not have them secured in the way that we would want to. So I think that's an issue. And I think actually the paper issue is something that tends to be overlooked a lot lately. Because now that we have been mostly in an online environment for such a long time, people forget about it. But a lot of those old papers have sensitive information in there, and they have the information that could allow people to steal people's identity or do a lot of other things that they shouldn't do. So even though our law is referencing financial or threats to your finances, since the time that law was written, there's been a whole lot of other types of threats that have come to fruition, right? So we have people who will use, your passport information to cross into other countries. People who can use your health information to get health services pretending to be you. There's just a number of different things. They can also use it, and probably many of you know about this, they can also use your information just to embarrass you and harass you, put up fake identities, put up identities that are made from more than one person. All these sorts of things are possible, and there are new risks that weren't anticipated when those laws were written. And keeping practicing the fair information practice principles, and particularly data minimization, really helps us to curtail a lot of that. So next slide, please. Okay, so there are a total of 8 fair information practice principles. Use limitation. So we should only use PII for the purpose specified in our notice. It's always good to say that and to put that out there. And I know many of us have seen this. I usually, scrolling on my phone with iStrain, see this where people say, oh, we're going to share this with so-and-so or whatever. The use limitation part is where you want to tell people what you would be using their information for, and only use it for purposes that are compatible for that. So it may be that you're collecting this information to, start a case for them. And, that information may need to be shared with private detectives, different, whatever it is. It's always a good idea to let people know what the breadth of that is, what's sort of covered in there. Usually, and to my disappointment, a lot of times the language that we see when we ourselves are doing this is that it's vaguely written and it's hard to understand, right? And it's like related parties and our, affiliates or whatever. And you're like, what does that even mean? The clearer that you can be about it, then so not only is it in keeping with the fair information practice principles, but one of the great things about it is that it gives you the reputation of being someone who values privacy, and that in itself can help boost business. So businesses are now starting to use privacy as one of their selling points, that they value privacy, and this helps to bring business in because people feel like they can rely on you. Data quality and integrity and security, these are really security focused things, but we should only, but the point of them is this, that we should only be collecting to the extent that it's possible that we can ensure that it's accurate, relevant, timely, and complete. So if we have a case that's been going on for years and we have 6 different addresses for a plaintiff or a defendant or a witness or what have you, we should be keeping what's relevant and keeping that in what's our current, what our current case is, or a case file is, or in our current system that we're keeping all this information in. When we keep all this old excess stuff, then it becomes harder to determine which is the correct version and which is the correct information. And so to the extent that it's practical, we want to update that information and only keep what we need to, what's current, to make sure that the data that we have is the right data. I feel like that makes sense when you think about it. But like, I look at my stuff and I have, like my address book has like all these old addresses just kind of half scratched out. And then sometimes like when I'm going to look at them, at the holidays and I want to send out cards, I'm like, well, which address is this? I can't tell. I've written one in one pen color, one in another one. It's that sort of a thing. So also, when we get rid of all of that excess and old data, then we decrease our risk of having stuff inadvertently modified, where one person thinks it's one thing, one person thinks it's another, and we wind up with something that's not the correct information. And we also decrease our risk of inadvertently disclosing information that we shouldn't be. Accountability and auditing. So the organization should be accountable for complying with these principles, and we should have mechanisms to make sure that we are. So one of the things that I really love, and I feel like accountability and auditing, this goes a little bit, is maybe sometimes advanced depending on the size of an organization. But I think having privacy awareness and talking about these principles with people right when they start work and have yearly discussions about privacy really go a long way to integrating these fair information practice principles into the daily business work life. And when we do that, then we increase our ability to keep information private. We increase our reputation as someone who supports and protects privacy, and we decrease our risk of being subject to, ransomware, identity theft, all these sorts of things. So these are good principles to keep in mind, understanding that they are underpinning most of the laws that we see, and that if we ourselves are practicing them, then we're a long way towards compliance, no matter what the regime is. Okay, so next slide. So one of the things that I was asked about was about data classification. And I'll just tell you that data classification is a confusing issue for many, many people. And when we look at how do we determine how we're going to classify data, right? So data is generally into 3 classifications: high, medium, and low. And this is the level, what we're talking about with this is the level of protection that we'll need to put onto something in order to ensure the confidentiality and things like that on it. So what we can do is we can look at, so we have the North Carolina Media Protection Policy. And that policy has different charts that look at North Carolina specific laws and how we would, what level of protection we would put onto particular types of data. So I think that might be especially helpful for this group. But also I have added in here a link to a model for creating data classification, a data classification and protection guide that comes from Harvard. Now, I really like Harvard's one because one, it's just 2 sheets, it's nice and easy to see. And if we were thinking about how are we going to increase privacy awareness in order to make us all safer, having this, printing it out, creating something like this at our offices, and then having them up in places where people can see will go a long way to making sure that protection is in place. So my boss always tells me, since I'm in IT, that, the paper thing, no, you shouldn't do that. And I'm kind of old, so I still favor that. But you can also have it as a screensaver, right? Or have it as part of your quarterly training or something like that. So along with, bias training and all of that, having privacy training will go a long way to help with that. And also looking at data classification in an image. A lot of people are able to take it in better that way. And I think that what you'll see is that is helpful. Now, one thing I think that it's important to note is that if we're looking at data or systems that include multiple classifications of data, so some data is like medium and some data is high, the default protection that we would want to put on a system is going to be high, because we have to protect the whole system, right? Rather than just that one little piece of data that's in there. So when we look at anything that would have high classified data in it, then we need to, the default for the protection for whatever that system is, or whatever, even if it's paper documents, for how we're handling those documents should be at that higher level. And the only reason that I bring that up here is that if you were to read some of the things like the FIPS, and let me say here that FIPS stands for Federal Information Processing Standards. That's a different type of FIPS, that if we were looking at that, I don't feel like that's something that jumps right out at you when you're looking at that manual. And I think that it's important to know that and to just think about it from that perspective, that whatever is our highest level of data protection, the highest level that we have to be protecting certain types of data, that would apply to whatever the entity is that's holding it, even if it's holding lower a lower requirement for security on the other data. Okay, so I think I have covered that. Yes. Okay, so next slide. So this is what our data classification looks like. And so the data classification that the state uses is available in our media protection policy. If you look online, you'll also see that we have a data handling and a data classification and handling policy. Both of them have this information. And what we can see is that we've done it in a way that's similar to what I'll be showing you that Harvard does, which is that we have low is in green, right? Just like we would do with our stoplights, green. And that's would be for information that's not made specifically confidential by state or federal law. And so it's the kind of stuff that you would see in routine correspondence. So like I was talking to you about how, as the chief privacy officer, my name and my, work email and all of that would be in there. That would be low risk data. Then we've got our medium risk data, the yellow, proceed with caution, think about the things you need to do. The thing to think about with this is that what we're providing here is a list of the different types of information that would need to be protected at medium risk. But it has to be looked at in context, because if we have information that's also in the high risk, so personally identifiable information mixed in with that, then that would kick that whole thing into being that higher level of security that would need to be applied to it. So that it would have the classification of high then. So I hope that is making sense. And so what I've added on the side here are a couple of different other places that you can look for information. So NIST SP 860, and there's a hyperlink to this. That is a guide for mapping types of information. So if when you looked at our manual, you didn't see the types of information you were looking for, you could go and look there. I also added 866 R2 means so revision 2, it means it's been updated the second time. This is a guide for if you work with HIPAA data and you find HIPAA confusing. This is a guide to help you to implement the privacy controls that you would need on the HIPAA data. Okay, and next slide. So I couldn't leave without putting in this information from Harvard, because we are in the process of updating our media protection guide and updating our classification guide. And I just really love the way that this is put forward. I love the, green, yellow, like a light orange and a darker orange and a red to look at the, what's the level of protection that needs to be on it, how secure does it need to be. And I also like that the way this is done is that it provides you with what is the definition of this. And, what is the level of disclosure? How should you be thinking about it and concerned about it? And then it gives you examples. So here's some examples here. So we can see like this, the light orange is talking about FERPA data. So that's the federal education data. And then we can also look down and see that vendor contracts and NDAs would be in there, right? So we would want to proceed with caution there. But when we looked at what would be in a higher level, that's usually, so like the red level stuff is usually for things like stuff that deals with national security, stuff that deals with finances, stuff that deals with that would cause severe harm to someone if it was exposed. So you might have cases that deal with specific medical conditions, things that have happened to people in response to car accidents or who knows what. those sorts of things that could really, harm them psychologically, emotionally, in their communities, and that sort of stuff would fall into this red zone. And so I love that this provides examples under it. And if we were to think about this and we were to think about how we would increase awareness in our own institutions, this would be a great way to have this sort of a thing as an easy reference, because you can always look back for more information later, but a quick reference that would give you an idea of what level of protection you should be providing immediately is super helpful. So what you're not seeing on this screen is that, and I've given you a link to this Harvard guide. On the second page of the Harvard guide, it talks about how to handle this information. So what protections would you want to be putting on that? And for this reason, I love that it's 2 pages. I love that it's easy and it's color coded. I love that it is designed for people who need the details, but also for people who need to be able to see the big picture. So for a lot of reasons, I really favor this style, and I think it's a good one to implement to help people to get on board with the idea of information security and data protection. And then next slide. Okay, so I feel like I've thrown a lot of stuff out there in a very short time. And I'm happy to take questions now. And then if you think of questions later and you want to reach out to me, you can reach out to me through the DIT privacy at nc.gov website, or you can email me directly. You can look me up and I'm happy to talk about privacy. And then the other thing I would say is we do have information for businesses on that website that was a part of this slide deck. And I recommend going there as well. And I am totally open to any additions you think might be handy for the business community and for the legal community for us to add to it. Okay, are there any questions? I'm getting silence. I'm assuming there's no questions. Well, that concludes my slides and my talk.
Sherry, thank you so much for taking the time today to talk to all of us about such an important topic. We really appreciate it. And I apologize too. I realized because we got kind of tied up with the Zoom, I did not give you the introduction that you properly deserved. So I just kind of wanted to give you that at the very end, if you don't mind. So folks, just as a reminder, Sherry Givens is the Chief Privacy Officer with the North Carolina Department of Information Technology. She's responsible for strategic and comprehensive statewide privacy programs that define, develop, maintain, and implement policies and processes that enable consistent and effective information privacy practices. She is a certified information privacy professional and an attorney with more than 20 years of experience. She joined NCDIT in December 2021 after more than a decade supporting federal privacy programs in the Washington, D.C. area, first as a federal employee and then as a contractor. And she has been so kind to take her time today to talk with us about such an important presentation. And you do have a question in the chat, Sherry, that I will share.
I did see that. Okay. I'm looking right now because I actually don't remember the name off. I don't remember the one offhand.
So I'll just read it just for the recording. It says, you mentioned that there was a federal law getting away from the use of social security numbers and that NC has adopted it. Do you have a statutory reference?
Yeah, and that is something I will have to get back to you on, because I was looking at it just the other day, but I have forgotten what it is. So the federal act came out in 2017, and we did adopt that, the mindset of that, and the gist of what the law is about not putting social security numbers on printed documents, don't put it through the mail, that sort of thing. But I don't remember offhand what it was called. I do apologize for that. I would have to get back to you on that one. But a general search will, I think, pull it up because we're one of a number of states that do it. But in general, everybody is now following this model. And the reason is that social security numbers are such an easy way for people to steal identity. So it's not that you can't use them at all. It's just that you want to reduce where you can the use of them in places where they can easily be seen.
And do you have any problems with us sharing the presentation, the PowerPoint from today?
No, please do.
Okay, great. So we'll email that out to anyone who had signed up and so they can have it on hand for reference. Does anyone else have any other questions for Sherry? Going once, going twice.
Okay, so I'll just
All right.
wrap by saying, I know that I mentioned a lot about security. So the NIST documents will tell you about basic things you can do for security. So I think a lot of times, particularly if we're in smaller firms, it can feel a little overwhelming, like how do we go about doing this? And NIST will give you guidance on that. So they have specific guidance on how to destroy data, right? So like, if you're getting rid of old case files that have PII in it, what is the means to destroy it? You know, with shredders that shred documents to a certain level. How do you destroy, CD-ROMs and things like that? It's got guidance in there for that. And I think that it will help you get a better understanding of what we should be doing. Anyone who's not encrypting email, there's plenty of things that you can do to encrypt your email. Everybody should be doing that if you're sending any kind of PII. There are also apps that have that can let you send encrypted emails back and forth. Proton, I think, comes to mind right now. There's also I'm trying to think along those same lines. Anybody not using a VPN when traveling, right? You should want to use one of those. That's a virtual private network. So if anybody listening now has not been doing that, these are very inexpensive ways that you can, inexpensive measures that you can take to start protecting privacy and to make sure that the information that people have shared with you is protected. Okay, well, I think that's it for me. I do appreciate your time. I always love to talk with people about privacy. I think it's so important. And I think one of the biggest challenges is just awareness. And I think once people are aware, then it becomes so much easier. So please do reach out if I can be of service to you in the future. And I appreciate your time.